Hello, everyone. I'm Kip Randall. I'm a partner in the Husch Blackwell White Collar Internal Investigations and Compliance PSC. Before we begin, I'd like to cover a few housekeeping items. At the top of your audience console, there are multiple applications for your use during the program today. If you have any questions during the podcast, please submit via the question box. We'll try to answer all the questions during the webcast today, but if a fuller answer is required, or we run out of time, we'll answer them later by email. A PDF of the panel outline is available in the program materials folder. Auto-generated closed captions are available for today's program. To turn on closed captions, click the CC button in the bottom right corner of the media box player. This program has been approved for legal education hours. For live attendees, report your hours by clicking on the continuing education sign-in link at the top of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for you to watch and share. Today, at the end of the program, be sure to complete our short survey. We use your feedback to plan future events that are applicable for our business needs. This is all the housekeeping items. Let's get started with our program. Presenting with me today are Anita Pincholi and Kurt Lepanovich. Anita is an accomplished labor and employment attorney with corporate and law firm experience. She's adept in advising senior leadership, leading cross-functional teams, and providing business-minded legal solutions. She currently serves as Associate General Counsel and Head of Labor and Employment at Attentive Mobile. Attentive Mobile is a venture-backed unicorn that pioneered SMS marketing technology. Prior to Attentive, Anita was the General Counsel of Global Labor and Employment at Nielsen Media. Before going in-house, Anita represented diverse clients across industries as a labor and employment counsel, practiced general litigation, and completed a federal district court clerkship. I've had the pleasure of speaking with Anita on this topic before. I know you'll find her insights very helpful today. Kurt is a special investigator in Husch Blackwell's White Collar Internal Investigations and Compliance PSC. He's a former FBI special agent with over 26 years of experience leading high-profile investigations in financial crimes, public corruption, and child exploitation. He served as a senior resident advisor and held certifications as a firearm instructor, tactical instructor, and SWAT team sniper. Prior to the FBI, he practiced law with a focus on federal and state tax strategies. At Husch Blackwell, Kurt combines his legal and investigative expertise to support clients in white-collar defense, internal investigations, and compliance. Kurt and I have worked together frequently on investigations, and his insights are always invaluable. I also note that since he's been working for Husch, he has not needed to use his sniper skills. So before we get started with the substance, I'm going to flip to a quick poll. And this is, how experienced are you with internal investigations? The options are A, 1 to 5 investigations, B is 5 to 20 investigations, or C, 21 plus investigations. I'll give a few minutes for the attendees to make their selection. All right. So it looks like we have a good number of submissions here. So, all right, that's great. So it looks like we've got a little over half on the lower end of the spectrum, and then on the upper end of the spectrum kind of split in quarters, which is great. It looks like we have a wide range of experience here. So that's perfect for today's discussion. So to kick things off, I want to talk about the moment an issue arises and sort of our initial considerations. So Anita, I'm going to put you on the hot seat for these first questions, if you don't mind. A lot of times in our practice area, internal investigations are triggered by an inquiry from the government through a subpoena or a civil investigative demand, but obviously that isn't the sole trigger. Can you talk to us about some other triggers for an internal investigation?
Yeah, thank you, Kip. So as an in-house attorney, right, I want to take a step back here. when I think about investigations in general, one of the most important things to be on top of is simply finding out about the need to do an investigation in the first place. It's very common and easy for issues to arise in a workplace, but for the people who need to know to investigate, to never find out about them. And so for the in-house folks, you really have to have a handle on your reporting mechanisms and you have to actively manage them, right? So investigations can be triggered by a number of potential reporting events. First, you could receive a simple allegation or a complaint by an individual. These could come from a number of different individuals in your organization, anyone who is purporting to act as a whistleblower. They could come from employees, contractors, customers, or even third parties such as vendors and suppliers, right? And they can come in a number of different ways too. Complaints could be reported directly to someone in your human resources department or someone in your legal department or your compliance function. This is great if it happens. This is exactly what we want to happen because it means that individuals know and feel comfortable bringing reports forward to the right people. And more importantly, they know who to go to. Complaints could also come directly to managers, right? This is very common. Managers are anyone in your organization who is a people manager. Managers can impute knowledge and liability to the company. So they are a very important piece of your reporting puzzle. And it's imperative that managers are trained on what to do with the report when it comes in. The answer is not for them to investigate themselves, but rather to inform legal or human resources or your compliance function. I do tend to do an annual manager training to reiterate what kinds of issues should be immediately escalated. Complaints could also come to other prominent executives or high-level employees in your organization. For example, your equity, inclusion, and belonging department or executive. Again, it's very important for these executives to know what to do with complaints when they come in. Complaints can also, of course, come in through any sort of anonymous reporting mechanism you may have, such as a reporting hotline. You know, as you know, public companies, of course, are required to have anonymous reporting mechanisms, but it's best practice for all organizations to have some sort of anonymous reporting mechanism. So, you know, again, taking a step back within your organization, you really want to actively work at and campaign around your culture of compliance and make it a visible value. I do tend to advertise a Speak Up campaign around the time of annual compliance training. I try to work it into communications. You may get some noise in the process, but I think that's just a small price to pay for getting the information that you want, which is for individuals to come forward through internal reporting before it becomes a larger issue, right, involving external forces. Which brings me to other ways that investigations can come to our attention, right? You can have regulatory inquiries. Sometimes a government agency or regulator may reach out with questions or requests for information that suggests some noncompliance. That does put you in somewhat of a reactive and defensive position. So you will have to move very quickly in these situations to get to the investigation. Audit findings. You may have an internal or external audit that uncovers some sort of irregularities, right, or red flags, some unusual transactions, accounting discrepancy, or violations of company policy. You want to look into those. Media reports. Sometimes, you know, it could be negative press coverage about the company or its employees that trigger the need to look internally and to investigate. And then, of course, there's litigation. The filing of a lawsuit, especially one alleging any wrongdoing on the company's part, should prompt an immediate internal review to understand the underlying facts. This, again, puts you in a very time-sensitive position, so you want to move quickly.
Thanks, Anita. That's really helpful. I especially like your comments about the culture of compliance and how important that is. It's critical that a whistleblower is coming to you first internally before it gets to some of these external triggers, and that's really critical. And so a good culture of compliance is where you have those complaints coming in coming forward and those people coming forward to you and letting you know so you can look at those issues. If it then gets escalated to a government inquiry, you can go to the government and say, look, we've looked into this, this is how we've addressed it. And so that helps from the very beginning to have that internal trigger versus being, as you said, kind of being in a reactive state back on your heels with sort of an external trigger. So that's very helpful. So what's the first thing that you do when there's a trigger? What's your initial sort of reaction to that? What are some of the steps you take there?
Yeah, so the very first step is to just assess the immediacy and the urgency of the allegation that's before you, right? You want to think quickly, what are the potential legal, regulatory, or reputational impacts of this issue? Basically, what could happen to the organization as a result of this allegation? And you want to determine whether there's some immediate action you need to take, whether it's to preserve evidence or protect individuals, or protect the company. Ask yourself, is there a risk of imminent harm to any individual or to the company? For example, if there's an allegation with some immediate safety concerns, right? Say sexual harassment where two people work very closely together, a potential assault allegation, or potential theft of company resources, then you want to think immediately about what immediate actions you need to put in place to prevent that imminent harm. You may consider separating two people in the workplace, perhaps a paid leave of absence for someone who is accused of gross misconduct, and other, potential immediate solutions. While you are doing this initial assessment, it's really important to maintain confidentiality, and you want to avoid tipping people off. And then, depending on the situation, you may consider some sort of immediate document preservation steps, like a legal hold, to preserve any evidence.
So, based on those sort of initial steps, then what do you need to do to decide if you actually need to proceed with an investigation? What's your thought process there after you've kind of gone through this initial analysis to say, okay, yes, now we need to proceed with that internal investigation?
Yeah. So I have a very, very short answer to this, and it is usually your answer is going to be yes. If it's a small issue, if it's a big issue, if it's something in between, you want to err on the side of conducting some sort of investigation and documenting it, right? Especially if there's any allegation of treatment based on protected class, unfair treatment, misconduct, allegations of policy violations or law violations, any sort of fraud. Now, there are certain situations that are purely employee relations type issues or, personnel problems that don't have policy or law or safety at issue. And you can pass those off to your, other departments, such as your human resources department, to manage. Short of that, I do think, and I err on the side of legal wanting to be involved in the investigation, right? And the reasons are this. First of all, you have legal and regulatory obligations in some situations to investigate. So that is very straightforward. An investigation can help you make factual determinations and to take remedial steps if you think those are needed. And if you can get on top of any remedial action early, then you can get ahead of and even prevent the issue from becoming external, just as we said, such as an agency investigation or litigation or some potential reputational harm. You also want to put the company in the best defensive position possible in the event of some possible litigation or regulatory action. And there are certain defenses that are only available to the company if a proactive investigation was conducted and the company acted responsibly. And lastly, in my view, your company's culture and morale kind of depend on it. Investigations show employees that you take issues and concerns seriously, and this will just help reinforce your culture of integrity. So there are some pitfalls, of course, right, of not doing the investigation. So what if this is an issue we've already looked into before? What if it's a complaint by someone we kind of know to be a complainer? Or if it's a complaint that was raised in a resignation letter and the person isn't here anymore, do we still have to look into it? Or what if the complaint is about how a prior investigation was handled? Someone saying that we botched it. The answer is generally yes. You do want to look into it and document it to protect the company.
So it sounds like in a number of situations, other than potentially just those employee relation situations, you're recommending that at least some level of internal investigation is done. And I completely agree with that. So you're now at the point that you've decided that an internal investigation needs to be completed. How do you decide who is going to manage that and oversee the investigation?
Yeah, that's a great question, because choosing the right person to conduct it is very important. First and foremost, you need someone who's going to be a good listener, right? And who has a high level of attention to detail. And you have to ensure that there's no bias or even perception of bias in the process. The investigator should be someone who can keep an open mind and not prejudge, right? And really follow the facts and not, jump to legal conclusions or insert opinions into the process. So, for example, if there's someone who would say, I know that person, and they'd never do that. Or if they'd say to themselves, I know that person, and of course, I bet they totally did that. That person shouldn't be your person investigating. So in addition to someone who is objective and detail oriented, you also want to consider who has the necessary expertise, who has the authority to lead the investigation effectively. For routine issues, again, personnel issues or things that are less serious, you can have HR or compliance lead it with some legal support as needed. For allegations involving management or potential criminal conduct, things with significant regulatory risk or legal risk, then generally legal leads those investigations, sometimes with direct oversight from your chief legal officer or your general counsel or your board of directors. And then there's the issue of independence, right? If there's a conflict of interest, or if the issue involves senior leadership or your executives, it might be appropriate to have the investigation overseen by outside counsel. Which brings me to outside counsel, right? There are many situations in which it is most appropriate and optimal to bring in outside counsel to run the investigation. If there's a high risk of litigation or regulatory action, outside counsel can provide independence. Outside counsel can protect privilege from the beginning. Outside counsel is also very helpful to avoid any perception of bias or conflict of interest. If you need some specialized expertise, or if there are some geographic or jurisdictional considerations, for example, cross-border investigations or unfamiliar jurisdictions, that's where outside counsel can be very effective.
Okay, you mentioned the attorney-client privilege protections and that. Can you go into that a little bit further?
Yes, absolutely. So we could probably talk about attorney-client privilege for a whole hour here, but I won't bore everyone with that. Preserving privilege is always a very important consideration. In certain investigations with policy and legal implications, you want to make sure it attaches. And that will play into who conducts the investigation. Again, there's so much I could say about privilege here, but I'm going to focus on just one aspect of it. In order for the investigation to be protected, legal should be consulted and involved from the outset of the investigation. Again, there's a lot more I could say, such as, be careful of hitting reply all, or be careful of bringing unnecessary people into the investigation. But in general, you want to start by involving your attorneys up front. And that way, all of the attorney-client communications during the course of the investigation can be privileged.
So I think, you said we could talk about attorney-client privilege for the whole hour. We could also talk about just this sort of laying the groundwork for an entire hour. I appreciate you going sort of over those at a high level, hitting those key considerations as we're going through each one of these steps on deciding whether or not to conduct an investigation, who's going to oversee it. All that is extremely helpful. And we're going to move on to kind of how we're going to structure the investigation next. Before we do, I love to hear, what you think, what a common mistake is that you've seen in those initial stages of setting up the investigation.
Mm-hmm. Yeah, I've seen so many mistakes in investigations over my time. But something that really sticks in my mind is something I mentioned kind of earlier, which is just finding out about the need to do it because of the absence of proper escalation training in the first instance that an allegation is made. So there could be an internal report or some protected activity taking place, it going to the manager, and the manager kind of thinking that they know the people involved and wanting to kind of handle it themselves, or they kind of run their own little, let's look into what happened, without escalating it to legal or to the proper individuals at the organization. So I think that training component is very important.
Yeah, definitely agree with that. And so now we're going to move to sort of we're at the point where we decided to conduct an investigation. For our purposes, we're going to assume that outside counsel is going to be conducting the investigation. And so I'll kind of go through from outside counsel's perspective some of the things to be thinking about when we're structuring the investigation at this point. So kind of the first thing is to make sure that we are aligned with the objectives of the company. This is so many times we don't get aligned at the beginning, and then outside counsel is going one way and the company is thinking they're going a different way. I mean, this can also apply for an internal investigation that's done in-house. If there's not, the company is not communicating well. And so really this is about communication and making sure that we're on the same page. And so really we want to make sure there's an understanding of, what's the primary goal here? I mean, is it to determine the facts? Is it to comply with some regulatory requirement? Is it to prepare for litigation? Is it to reassure the shareholders, stakeholders in the company, or is it, some combination of the above? But it needs to, from the very beginning, we need to make sure that we are on the same page on what the ultimate goal is with the investigation. And then next, kind of in line with that is the specific outcomes that the company is seeking. I mean, are we talking about identifying if there's policy violations, internal policy violations? Are we talking about seeing if there should be something disclosed to regulators, and then are we thinking about remediating the harm at the end? I would say that in all circumstances, that's an outcome that we want to be considering, is remediating that harm at the end. But those are all things that we want to be thinking about, kind of the specific outcomes that we're seeking from the very beginning. And then also, this is going to continue to come back through, as a thread throughout this discussion is privilege, is, whether or not we're planning to maintain privilege over the investigation, or at some point, share the results with a third party, a regulator. And at this point, at the beginning of an investigation, I'd say that in most circumstances, you're not going to know whether or not you plan to share those results. And so we're going to proceed from the very beginning that we're going to maintain privilege. And then at some later point, we might decide that the company may decide that they're willing to waive that privilege and share some of those, but we're going to maintain that privilege from the very beginning. And then finally, we want to think about what is the end product? And this is kind of different from the outcome, because we're thinking about, okay, are we providing a written report? Is this going to be some sort of oral briefing or some other different type of end product? And, it's good to think about those sorts of things at the beginning, even though that can adjust over time. But those are some initial considerations you want to think about to make sure that you're, from the very beginning, you are aligned on those objectives. I mean, it's really critical to make sure that the investigation is properly scoped and conducted appropriately, and so that there's expectations are managed on all sides throughout that process. And so I'll pause there. Anita, do you have anything that you want to add there from the in-house perspective?
I think you hit it. Okay,
great. Well, perfect. I got a perfect score then on that one. So next, we want to kind of be thinking about who the investigation involves, and whether or not we're reporting to the right person. And this is it goes back to what Anita was talking about with who's overseeing the investigation. And so if we're thinking about who are the key individuals that are implicated from the an initial, if it's a whistleblower report, who is that whistleblower naming, and who's being implicated by that, and then are they current or former employees, third parties, senior management? Like, who are we going to be dealing with? Because there's a lot of different considerations there in terms of for instance, talking about whether it's a current or former employee, right? So if we're doing a privileged internal investigation, then those current employees will be within that scope of the privilege. But talking with former employees, that those interviews are not going to be privileged. And so that's something you need to think about, and kind of in structuring the order that we're going to be doing these things. Do we want to talk to the person who is potentially committing the misconduct? Usually you want to talk to that person last, and thinking of the order that you want to go through to get to that person, so that you have the most amount of information before you get to the alleged perpetrator there. And then, as I said, kind of who's overseeing the investigation. You want to think about who's your point of contact. If you're reporting to the general counsel, or an executive, maybe the whole board, or a special committee of the board, who that is, and making sure that when we're thinking about who the investigation involves, that where there's not some sort of conflict there. I mean, that conflict can be a direct conflict with the person has the allegation against him or her, and then you're going to want to probably be one or two steps above that person. Or it could be that if we're dealing with the general counsel, and the general counsel may have a personal, a close relationship with the executive, if there's an executive. And so then in that situation, we're going to want to, again, be above those individuals in terms of who's overseeing the investigation. That's important, just to ensure that there's the investigation appears to to be independent, and is in fact independent, and there's not some sort of appearance of impropriety there. And then kind of the last thing is, you want to consider whether or not, when this investigation needs to be independent, and for the regulators, auditors, the public, for this to appear to be an independent investigation. So really, it's important from the beginning to sort of set these clear lines of communication, understand who we're reporting to, so we can maintain that credibility and integrity.
Mm-hmm. Can I just add one thing to that, Kip?
Yes, yeah.
I completely agree with everything you said. And also, I think that, you could get an allegation that seems very clear, like, okay, it's involving X person, it's an allegation related to this, and you structure your outline, you kind of have your witness interviews, and then you want to maintain a certain level of flexibility in the course of that investigation, right? Because as you are talking to people, there's new information that could be uncovered, new people who you need to start talking to. And so, you kind of look at this issue at the very top. Who are the people involved? Who does the investigation involve? And then you might need to keep revisiting that throughout the course of your investigation.
Absolutely. And, along with that, one of the things that we want to be thinking about, kind of what laws and policies, company policies, are applicable to the investigation. Kind of from the beginning, that is important to understand the substance of, say we're dealing with some sort of securities fraud or wire fraud or something along those lines. It's important to understand the substance of those violations, obviously, and then where the company policies fit into that. But there's other sort of different elements that you want to think about, different laws that might play into this. And that's, if you're dealing with sort of an international, a global company where you're having to go across borders and things like that, and how that's going to play in, blocking statutes and those sorts of things are going to be important. And then, also with data, if we're dealing with the EU and, those sorts of things with the GDRP and all of that, those are all different things that we're going to need to take into consideration. And then whether or not the company has to, is required to report, if there are applicable laws that require the company to report their findings. That's, again, something that we're going to need to be considering from the beginning. And then if we're looking at the company policies and making sure that, when we're dealing with employees and things along those lines, that with the code of conduct and ethics and those sorts of things, that we're falling in line with that and what we're requiring of employees in terms of participating in the investigation and things along those lines. Those are all sort of considerations that we need to be thinking about when we're structuring the investigation. And then if there's nothing from Kurt or Anita, then I'll move on to my next section, which is really we need to identify the people that we're going to be talking to, the relevant actors and all of this. And sometimes you're going to get a complaint, whistleblower complaint that has a lot of information. And this is, one thing that I have heard with reporting hotlines is it's good to have those be live, have someone who can communicate there on the other end to take that report, because you can ask some of those follow-up questions and get additional information. But sometimes you might have a very limited complaint, and you're starting from a very, the initial starting point is very limited. And so you're going to have to build as you go. And something you have to think about when you're structuring it, do you need to do, scoping interviews at the beginning, kind of understand the full scope of the allegation? And, as you were saying, Anita, that, this is something that's kind of living and breathing as you go. There are going to be adjustments, but you don't want to start off, looking at under one, small stone and find out that there's a giant boulder that's just right behind it. And so you want to kind of at the beginning see if you can uncover as much of that so you can set expectations and properly scope the investigation from the very beginning. That really, you want to avoid any surprises, make sure you're doing a thorough investigation and staying sort of on task from the very beginning. And so those are all kind of, all of the stuff kind of discussed here keeps us in line with that and making sure that we're structuring the investigation from the beginning. But, before I kind of move on to the next section, which is Kurt's, and I'm sorry, Kurt, you've been sitting there quietly for this whole time, so you get a chance to talk here in a minute. But before I get to your section, I want to kind of talk about one common mistake with structuring the investigation is not properly structuring the investigation, right? Is to rush through this stage and kind of rush directly to let's start reviewing documents, let's start talking to people, and then because the company is anxious to find out what happened so they can make a decision. I mean, as outside counsel, we're anxious to provide that information, but if you don't properly structure at the beginning, you're going to get the scope creep where you're going off on sort of tangents that aren't necessarily relevant to the core issue. And then a lot of times you're going to, in those situations, you're going to, when you set that expectation with the budget at the beginning, you're going to exceed that if you're running off on and taking going down rabbit trails and things along those lines. So you just sit down and think about this through this, and all these different considerations from the very beginning, so that you're structuring that properly. So that's my thoughts there. Anything else to add on that, Anita, before we move on? I know that you definitely don't want anybody exceeding their budget when it comes to.
That's always not a great conversation. That's right. It just takes a lot of planning. I mean, you really hit the nail on its head. Is that it takes a lot of planning and a lot of effort up front in the strategy and the planning phase before you kind of jump into doing the actual interviewing and so on and so forth. So that's absolutely right. You want to sit down and be methodical about it and think proactively. What is the actual issue here? What is the actual allegation? What are the laws that are implicated? What's the policy issue? And that will help you frame things well.
And so getting into the next section, which is really the most fun, right, Kurt? This is when we're going to be executing the investigation, collecting the evidence, doing the interviews. And so, I mean, this is your bread and butter after, more than 26 years in the FBI. And then with the firm for so many years doing this for clients. Talk to us about, what your steps are for, the initial collection of the evidence.
Thank you, Kip. So first of all, you need to identify what the relevant evidence is. Determine what evidence is crucial to the case before initiating the collection process. My preference is always to be over-inclusive. It's much easier at the end to come back and say, I don't need this evidence, than partway through decide you need something to find out it's been altered, destroyed, or is no longer available. So that's my preference, is to be over-inclusive. Act quickly. Preserve potentially relevant evidence as soon as an investigation is initiated, including documents and electronic files. Things tend to disappear, so you want to move quickly to secure what you need.
And if I can jump in there real quick, and this is something that Anita mentioned at the beginning with a legal hold, but it's something that, is important enough to kind of reiterate here, that acting quickly to get that legal hold in place. And I'm on the firm's e-discovery team, so when we talk about legal holds, I start to get all excited and jittery, but this is it's really important, because from the outset we need to make sure that we're preserving those. Everything now is digital, and so getting the legal hold in place is to help preserve those things, but also to help to have a defensible investigation for the company. They need to show that they took those initial steps for the legal hold. So that's my plug there for acting quickly to get that legal hold out. So
you also want to document your preservation efforts. Maintain thorough documentation of all steps taken to preserve the evidence. That may be important later on. Obviously, but don't alter or delete evidence. Preserve the original form of all evidence and create a copy for analysis. That's typically done when they mirror a hard drive. Use forensic tools. Employ specialized software for collecting and preserving digital evidence to maintain authenticity and integrity. As always, I defer to Kip, because he is the part of the Husch Blackwell's e-discovery group. And so when those questions arise, I always kick that back to Kip. Secure evidence. Protect both physical and digital evidence from unauthorized access or tampering through secure storage and access controls. Follow the chain of custody procedures. Maintain meticulous record of every individual who handles evidence, documenting the date and the time and the purpose for the access. If there's no purpose, then they should not be accessing it. Right? Sort of like the need to know. Stay updated with technology. Again, I depend on other people's. I am not the most technologically savvy, so I rely on other people's, but make sure you keep abreast of the latest tools and techniques for preserving electronic evidence in a rapidly evolving technological era. Kip, you wanted to mention something, I think, cell phones, because that becomes a problem at times.
Yeah, it really does. So that's, people the minute you talk about their cell phone, they, that's with every bit of private information that we have on there, from personal text, pictures of our kids, to financial information, people get very defensive of their cell phones. But a lot of times there is very relevant information on cell phones. And, for some reason, people think that text messages are never going to be seen by other people. So they say things in text messages they would never say. And so that's it used to be the way with email, and now it's transitioned to text messages. And so that's kind of one of those things that it's very challenging to navigate. From an outside counsel perspective, we're advising the company here, based on your policy for whether it's bring your own device to work, or you have provide company devices to your employees. Those types of things is really going to determine whether or not the company has possession, custody, control, that buzzword of those cell phones, and whether or not they can collect those. But oftentimes there are going to be it is going to be extremely valuable information there on the cell phones. And now one of the things that we talk about with clients is, there are ways, we have vendors that use a very targeted program. So if you say, okay, we only want text messages between me and Kurt, then they go in and they just pull those text messages off the phone. They don't collect any other data. And it's helpful sort of in minimizing some of those fears. The downside of that is if later on you need other information from the cell phone, you have to go back and do another collection. So it's important kind of from the beginning to know what information you're gonna need off of that phone. And so whether you need to do a full mirror image of the phone, or if you can do one of those targeted collections of specific messages, but that's something to really be thinking about from the beginning of that collection. And
we had
so,
an incident. Good. Sorry.
Go ahead.
We had an incident in the last couple of years where a client's cell phone was seized during a search warrant, execution of a search warrant. And it came out later on, he told us during our interview that he had videotaped he and his wife doing something that they did not want to be sharing. And unfortunately, the government had that. So be wary what you put on your phone, because it can be seized.
That's exactly right. And so, we talk about here collecting the evidence first. We're talking about, documents and those sorts of things, because it's really important when we're getting into interviewing the witnesses, and the next step to have those documents and have a fuller picture of what's going on, and to be able to show some documents to the witnesses when you're talking with them, right? So and I don't mean to steal Kurt's thunder here in terms of what he's going to talk about, but that's kind of why we talk about collecting the evidence first, because we're going to want to do that prep on the front end, and then sit down with the witnesses once we have their text messages to review, and ask those questions and go through some of those things. So if you want to get into some of the steps, some considerations when you're interviewing witnesses, Kurt, that'd be very helpful.
And this is my favorite part, is interviewing witnesses. This is what I used to do as my bread and butter. Begin with thorough preparation. Review all available documents and evidence, and understand the scope and the objectives of the investigation. What are you trying to find? Once you know what you're trying to find, then steer the interview towards that. All right. If it's a key witness that we're going to be interviewing, I'll go so far as to look at their social media posts and try and find out a little bit more about them, to find out what I can use to get them to talk to us. Interview in private. You're not going to get anyone to, say, confess if you're sitting in a crowded room. You have to do it in private. Typically, we staff it with an investigator and an attorney. Kip and I do a lot of these together. You can do the interview either in person, remote, or hybrid. It depends on the situation. There's been times where you have to, if you're doing this, I call it a subject interview or a key witness, you need to sit down with that person. You can't do it by teams. However, if it's someone like maybe HR where you're just getting background information, that interview can be done via Teams. I've also done it where I'm on site and the attorney wasn't able to travel and they were remotely and we had them in by Teams. So we could do a hybrid interview. Upjohn warnings. I'll defer to the attorneys, but I always call it, Miranda for corporations. And there's requirements. If you're interviewing someone who's an employee of a company, you have to give them Upjohn warnings. And if Kip, you want to go into those? I'm assuming that most people know what Upjohn is.
Yeah, I mean, so an Upjohn warning is to make clear to the witness that you're not their personal attorney, that you are representing the company, and that because they're an employee of the company, that there's an attorney-client privilege that attaches to the conversation, the interview, but that privilege doesn't belong to the witness. That privilege belongs to the company, and the company can choose whether or not to waive the privilege or to maintain the privilege. That's the company's decision. The witness doesn't get to decide how, whether or not the company waives it or not. And so that's important for the witness to understand at the beginning. One, to understand how that privilege works, and two, that you're not their personal attorney. And there will be times when, the witness will say to you, well, do I need my own personal attorney? And we, as the interviewee, you cannot answer that question. You can't give them advice on whether or not they need an attorney. That's something that, we need to anticipate beforehand, whether or not someone might ask that, and the company needs to make a decision on whether or not we're going to indemnify an employee who wants to have their own personal attorney or not. So that's something to think about. There are a lot of different ways to handle the Upjohn warnings. I mean, you can handle that, really softly. This is someone who is, very friendly. This is not, you don't want to scare someone off. Or you can handle it, much differently, where it's much more aggressive sounding. And so that's just depending on who the witness is, how you want to approach that. And, I'll say, a lot of people are familiar with Upjohn warnings, as many that are conducting, internal investigations, but people aren't as often familiar with what are Weingarten rights. And something else I wanted to kind of throw in there real quick, and that's related to union employees. So if you don't have union employees, it's not applicable. But if you have a union employee and they're involved in an internal investigation, there are rights that you have to give them, which specifically tells them whether or not they're a subject of the investigation, whether you think that there's misconduct on their part. And if you do think that there's misconduct on their part, they have the right to have a union rep there with them. And so that's something you have to tell them at the beginning. If you don't believe there's misconduct on their part, there's someone else, you can say, we don't think there's any misconduct on your part, and so we just want to talk to you about this. And then in that situation, there's not a need to notify the union if we're not looking at their specific misconduct. So that Weingarten rights are not as well known as Upjohn warnings, but also applicable if you have union employees.
And once you get through all that, you still want to establish some sort of a rapport with the person you're going to interview. And how much rapport really depends on who you're talking to. Again, if you're talking to a subject or someone who has important facts, who may be somewhat hesitant to talk to you, you need to spend more time establishing rapport. If it's upper management, they've already bought in. They're the ones who signed off on the interviews, and you don't need to spend a lot of time with them. Case in point, reluctant witness, hesitant witness, not really wanting to participate. Did a search on him. He's my age. He's 65. He's a former maintenance guy. I looked at cars. He has a 77 Corvette. So when I went over to talk to him, I took my 68 Mustang, parked it right out front. We opened the front door. He saw my car. We talked about 15 minutes about cars before he even talked about anything else. So just try and find something to establish a rapport. And again, some people need more rapport building, some people need less. Structured planning. Schedule your interviews strategically and prepare outlines, but be flexible to adapt to unforeseen circumstances. As Anita was saying, sometimes someone else will pop up, hey, we need to interview this person as well. And as Kip was saying, it's best to circle around the edge before you go after the main person so you know more. However, there's times when that's not possible. Maybe the person has found out what's going on. And so there may be times when you will go in and you interview the main person, at least to lock them into their story so they don't have a chance to start thinking too much about what it is they've done. So it depends on the situation. I would say have a plan. What is, again, going back to what are you trying to learn? What is the investigation about? Focus your interview on that. I had to have a list of topics, but not a list of questions. It's a conversation. It is not a deposition. All right, you want to keep it friendly. Again, it goes back to establishing rapport. The bright light never worked for me when I was an agent. That's not how you interview people. That never worked. The good cop, bad cop, that's in TV. It never works. Maintain objectivity and confidentiality. Conduct interviews impartially, avoid biases, and maintain strict confidentiality throughout the process. Don't go in there with some preconceived notion. It used to bother me a lot when we would work cases and someone had an idea, it's got to be this person. As I think Anita said, follow the facts. That's what dictates the investigation, not some preconceived notion that it's got to be Joe or Susan or some other person. Use open-ended questions. Encourage witnesses to provide detailed narratives to facilitate the discovery of new information. Follow up with who, what, when, where, how, why, those kind of things to elicit more information. Document the interview. The old saying in the Bureau is, if it's not on paper, it didn't happen. So document the interview, create detailed notes. If my generation, I took notes. I know some people, younger people, they do it on their computer. I can't type that fast. I'm older. I still use notes. It's just the way it is. Whatever you're comfortable with. Also note what topics you're covering, and also notable behaviors. If they seem nervous, if they seem completely relaxed, if they seem a little twitchy, you want to document that as well. Consider language and translators. We have done a number where we have to use a translator. Interview witnesses in their native language. All right, if it means getting a translator in, so be it. Just note that it'll take at least twice as long to do an interview if you have a translator than if you do it in English.
Yep, those are there's a number of things that I want to hit in there the really good points that you brought up, Kurt. And I mean, this is when we're talking about an interview, this is just like any other, direct examination or of any witness. You want to sit and listen to what they say. You don't want to be reading off of a script. As Kurt was saying, you don't want to have a list of questions. You want to have a list of topics because you're going to let this conversation go where it's going to go. And so if you're just trying to go, each question and not listening to the answer because you're just going to the next one, this needs to be very open-ended, a very, very friendly conversation. I mean, I give Kurt a hard time about this all the time because he inevitably will ask someone if they're into, old cars. And I always give him a hard time about it, but it is one of the great things about him building the rapport with that person is if you're talking to them about their old car, they're not, they don't have their guard up. They're letting that guard down and they're going to give you more details. And that's not necessarily just someone who is, the person being, and the allegations are against that. It can be anybody. People are guarded. They're, when you come in wearing a suit, lawyers, they're instantly guarded. Right. And so it's better to sort of build that rapport. And, it's really one of the good things that, from the 26 years in the Bureau that Kurt has, carried over is, building that rapport and sort of, those relationships has really served him well in terms of investigations. But it's not always easy. There's some witnesses that do not want to talk to you. And so how do you kind of handle that, Kurt, when you got a difficult witness?
Yeah. Well, I will say it was easier in my prior job to get people to talk to an FBI agent than to talk to an investigator for a law firm. But that is one reason why you try to establish a rapport with the person. And sometimes you can, and sometimes you just can't. But again, never ever have I, even in my prior career, used the Sipowicz, or what I call the yelling approach. That never works. Always remain calm. Always remain nice. There's no way to get illicit information from someone if you're yelling at them. That just doesn't work. It's only on TV. So always try to establish that rapport. Attempt to identify the reason why they're being hesitant or hostile, and don't engage them directly. Right? Some people just won't talk to you. But if you can talk to them about something else, get them to understand why the information they have is important. Sometimes what I'll tell a person is, look, later on today you go to a bank, and while you're at the bank, someone comes in and robs it. You're just a witness. You don't really have a dog in the fight. You just happen to be someone who has information, and we want to talk to you about it. Put them at ease. Obviously, if it's the subject, that's a different story. But hopefully by the time you get to the subject, you've interviewed enough people peripheral that you have an idea of what this person has done.
Great. And I'm going to jump now to our next section, because we are running up close to time here. And so I wanted to get into our last section, which is reporting and remediation a little bit. So we've gone through all the evidence, we've done some analysis. So what is the final product here? And as we talked about before, that depends on what the client's looking for. We can do this sort of a privileged summary and oral presentation, not a written product, but there's a lot of different options there. And so I know this is probably going to the answer is going to be it depends. But Anita, what do you like to see sort of at the end of an investigation? Kind of what are your what's your thought process there in terms of products?
Yeah, it really does depend on the nature. It depends, right, on the nature of the investigation, the sensitivity of the investigation, the parties involved, so on and so forth. I think that at the end, legal will always and should make a recommendation on potential remedial action that the company could take. If there's immediate steps that need to be taken, if there's midterm steps, and then long-term steps, recommendations on policy improvements, process improvements to the company, I always welcome those and make them when I'm in the investigative position as well. And again, the remediation can take a number of different forms. It just really depends on the type of allegation and the type of issue at hand and what the investigation found. I also think it's very important, when we get to the end of remediation and report, and we made our official report, legal has a recommendation, there were steps taken. It's important to close out the investigation. I think this is forgotten a lot. That might mean following up with the complainant, and at that moment, taking a second to re-emphasize your non-retaliation policy. Now, the complainant doesn't get access to all your information. They don't get to necessarily know, for obvious confidentiality reasons, what remedial actions were recommended or what were taken. But they do get to know that their complaint was looked into, right? That it was investigated. In some cases, you may want to confirm your claims are substantiated or unsubstantiated. It just kind of depends on the situation. But you want to say to them, you have a direct line of communication to me in the future should these issues occur. It's important not to forget this step for the integrity of the investigation and the culture of your organization.
That's a really good point there, because a lot of times, whistleblowers who feel like their complaint wasn't taken seriously are the ones who then escalate it to the government, right? And so keeping them informed, letting them, know that you took their complaint seriously to the extent that, provide them the information you can along the way is critical to, keeping that relationship and continuing to, as you said, kind of build that culture of compliance, because people know that their complaints will be taken seriously, they will be looked into, and that they will, know sort of at the end kind of that something was done about it. So, so we are right up on time. I don't know if we had any questions come in here. Let me look at it does not look like we had any questions come in. So if you have any questions, feel free to submit those. We will respond by email to those, but really appreciate everyone coming and listening to us talk about internal investigations. So thanks so much for joining us today. We hope that you found this, helpful. And, sort of as a reminder, this program has been approved for legal education hours. To report those hours, go ahead and click on the continue education sign in link at the bottom of the top of the screen. And then you'll get a certificate of attendance, including course numbers and all of that emailed to you tomorrow with a recording. And if you would please complete the short survey. But this concludes our webinar. Thank you so much.